But the first one is legal. As Steve told you, in 1995, there was actually a trial in a federal court in Pennsylvania about whether intelligent design could be mentioned in a schoolroom. And it was held before this man, Judge John Jones, in the Middle District of Pennsylvania. And he ruled very strongly that no, it cannot be. Because in his opinion, intelligent design is not science. Intelligent design is religion. What's more, the reasoning for intelligent design is shoddy. And he used his opinion was very strong and very well written. For example, he said the following: "Indeed, the assertion that design of biological systems can be inferred from the purposeful arrangement of parts is based upon an analogy to human design. Because we are able to recognize the design of artifacts and objects, according to Professor Behe, that same reasoning can be employed to determine biological design. Professor Behe testified that the strength of the analogy depends upon the degree of similarity entailed in the two propositions. However, if this is the test, ID completely fails." Oh, and I guess I forgot to mention that I was an expert witness at the trial. And I had lawyers in my face about this far for 3 full days. It was great fun, great fun. Kind of like going to the dentist. And Judge Jones was widely hailed for his wisdom and his strong ruling against design. And here's another man. Meet Eric Rothschild. Eric Rothschild was the lead attorney for the plaintiffs in the case, the other guys, not the side I was on. And I didn't know it because I know nothing about law or such things. But it turns out that after a trial is over, each side presents to the judge something called a finding of law and conclusion, or finding of fact and conclusions of law, essentially in which they write what they really hope how the judge will rule, how they see things, and the way they want the judge to see things too. And actually, if you look at the judge's opinion and compare it to Eric Rothschild's written document, you can see echoes of the document in his writing. For example, Judge Jones wrote, "Indeed, the assertion that design of biological systems can be inferred from the purposeful arrangement of parts is based upon an analogy to human design." And Rothschild wrote, tell me if you can see this here. Look. "The assertion that design of biological systems..." But this wise judge knew that he should put an indeed right here, and that clearly this preposition should be upon and not on. And he continued, but Judge Jones realized that according to Professor Behe, he should go first in the sentence over here, and because should go after that. And here, Judge Jones knew that this should not be a separate paragraph. And this should have a however. Whenever he was writing about expert testimony, not only about me, but about the guys on the other side, the biologists on the other side, and philosophers, academic philosophers, whenever he was talking about expert testimony, he just copied essentially what he was given. When he talked about the school board and what the newspapers wrote, he used his own language then. But with the expert testimony, it was cut and paste. So the point is this, that judges can't rule on the validity of intelligent design. They're certainly welcome to rule on the legality of it. But whether one explanation for the bacterial flagellum is better than another is not in the judicial province. And Judge Jones, even though he had to sit through the trial, his background did not prepare him for this. He has a law background, a political background. His previous claim to fame was a stint as the director of the Pennsylvania Liquor Control Board. So the point is that you cannot surrender your judgment on these issues to somebody else, even if it's somebody as well regarded as a federal district court judge.